Child custody, a powerful alternative for non-custodial parents to obtain joint legal and physical custody of their children. The American Coalition of Fathers and Children's Rights Advocates define court-determined custody as not a right to parent one's children, but as the power to prevent the other partner from parenting. They also state that the outcome of divorce is overly one-sided and is initiated by mothers in more than 2/3 of cases, especially when children are involved. Divorce provides advantages for women such as automatic custody of the children and financial benefits in the form of child support payments. Family courts are secretive, censoring, and punitive towards fathers who criticize them. They also claim that employees and activists within the court support and benefit from the separation of children from their parents, and that family law today represents civil rights abuses and intrusive perversion of government power. They find that it is often too difficult for fathers in financial hardships or those who take on a larger caregiving role with their children to have their child support payments lowered. They also state that unemployment is the primary cause of child support arrears and that they only serve as a means of exposing the father to the risk of being unjustly arrested and illegally imprisoned without due process. Child support activists also point out that the current guidelines are arbitrary, providing mothers with financial incentives to file for divorce to intentionally impose burdensome financial obligations on fathers, leaving them with little discretionary income to enjoy with their children during their parenting time. The dichotomous state, complicated duplicity. What do the courts have to say? Parents have a fundamental constitutionally protected interest in continuity of legal bond with their children. The liberty interest of the family encompasses an interest in retaining custody of one's children and, thus, a state may not interfere with a parent's custodial rights absent due process protections. A father enjoys the right to associate with his children, which is guaranteed by this amendment, as incorporated in Amendment 14, or which is embodied in the concept of liberty as that word is used in the Due Process Clause of the 14th Amendment. A parent's right to care and companionship of his or her children are so fundamental as to be guaranteed protection under the 1st, 9th, and 14th Amendments of the United States Constitution. No bond is more precious, and none should be more zealously protected by the law as the bond between parent and child. To understand the divorce outcome, we must start before the marriage. What do the state statutes and codes have to say? Any marriage certificate is a contract between the priest or justice of the peace and the applicants. Alone, it has no effect in law unless the signature parties agree to litigation concerning the certificate. If the priest adds the certificate to the license application, the court may issue the marriage license. The marriage registration contract is between the district court and the state's registrar of vital statistics. The first line style and many others in the marriage license registration is in a barely legible Old English that reads wording to the effect of conveying a strong constructive notice of Old English law. Anyone that adheres to any contract by submitting documents and paying fees gives evidence of its validity. The applicants and state authorized officials are the only parties to the marriage contract. Later, family documents will find the applicant's signatures on marriage certificates along with the authorized clergyman's signature. When the state accepts the completed marriage certificate with the license application, the certificate then becomes an element of the license issued. This is a combination of two documents to make a third. Church courts and clergy have been long recognized as lawful witnesses to traditional lifetime marriages. The clergyman is the master of the marriage ceremony, and any family could seek marriage counseling from the church at any time. This tradition is older than the state constitution or the U.S. Constitution. But now, it seems, the state has combined the concept of church ceremonies with the state ceremonies. It's a matter of symbolism of authority and a matter of deciding which authority has jurisdiction over the inhabitants of the county. The husband and wife do not have to be married to each other. Their proxy automatically falls under trust law. When the couple applying to the marriage license signs the document, Are they even aware that they are entering into a trust agreement? Their voluntary pleading or application to any office or court is a confessed judgment and is entered on the judgment roll. The trust and lien are then in place. The district court judge appears to be the administrator of the marriage trust. The marriage license must be obtained from district court. Mutual obligations of husband and wife. Husband and wife may contract. Either husband or wife may enter into any engagement or transaction with the other, or any other persons respecting property which either might, if unmarried, subject in transactions between themselves to the general rules which control the actions of persons occupying confidential relations with each other, as defined by the provisions of this code relative to trusts. Trust not valid unless signed by trustee, signed by trustor, or by operation of law. Constructive trust. A constructive trust arises when a person holding title to property is subject to an equitable duty to convey it to another on the ground that the person holding title would be unjustly enriched if he were permitted to retain it. Black's Law's definition of a constructive trust. Trust created by operation of law against one who, by actual or constructive fraud, by duress or abuse of confidence, or by commission of wrong, or by any form of unconscionable conduct or other questionable means, has obtained or holds legal title to property which he should not, in equity and good conscience, hold and enjoy. Constructive trusts that arise by operation of law are valid. A trust not expressed is constructive and resulting. When application shall be made for a license to the clerk of the district court, he shall, upon granting of such license, state the Christian names, surnames, residences, birthplaces, ages, races, and previous states, whether widowed or divorced, of both mothers and fathers of both husband and wife, along with which license shall, prior to the issuing thereof, be entered of record in the office of the clerk of the district. If on such testimony being given, it shall appear that either of the parties is legally incompetent to enter such a contract, or that there is any impediment in the way. District Court supplies license for Minister and Justice of the Peace. Minister and Justice of the Peace certifies the ceremony and returns both to the District Court. Court record certificate form, join in lawful wedlock. Husband and wife contract toward each other obligations of mutual respect, fidelity, and support. All obligations, hubby and wife, are as joint tenants, example, renters on the king's realm under the king's law. The state of, by way of its district court of chancery, notices the application for marriage license and accepts and registers the trust contract with the one and only sovereign. The now licensed miscegenation is controlled by a written or implied lien and administered by the district court. In this type of trust, the married couple, as beneficiaries, have no control of the conditions or terms of the trust. The married couple is also the trustor. They are the creators of the trust. As trustor, the couple has the duty of providing the value or the duty of performance implied in the contract. The church-assisted marriage was by our open consent and voluntary. The chancery-assisted marriage is by our implied consent and mandatory. Marriage is a personal relationship between a man and a woman arising out of a civil contract to which the consent of the parties is essential. A marriage licensed, solemnized, and registered as provided in this chapter is valid in this state. A marriage may be contracted, maintained, invalidated, or dissolved only as provided by the law of this state. License required for marriage. Marriage is a man-woman contract and requires consent and solemnization, done before a public official. District court may issue license, and the certificate must be registered. When certificate is registered, the contract is valid. No resident may be joined in marriage until license. The license authorizes the ceremony. A non-resident license may be obtained through the district clerk, and charges are $30 for a certificate and a license. Any judge, mayor, justice of the peace, etc. can solemnize a marriage, but only a district court can license and register. A man and a woman purporting themselves as husband and wife have entered into a contract of marriage. Such adherence to a marriage contract under state statutes is evidence that the applicants are the persons named on the contract or their human representatives. When the state registers the completed marriage license, the contract falls under trust law as seen below. Due to the constructive trust, titles are bifurcated, meaning the state holds legal title, and John the owner becomes equitable owner, meaning the title held by John the owner from the state somewhere indicates a notice of lien, meaning or referring to other security interests on its face, a secondary notice of lien in other words. State records are passed along to any other state or federal agency. The secondary lien is in its place no matter who else liens it thereafter. Anyone with competent interest in the trust property has the duty of inquiring into the conditions of the contract. Failure to inquire puts such person into the status of incompetent beneficiary or acquiescence. The state shall take constructive notice of such status and lien. Is the same concept applicable to the terms of a marriage contract? If the husband and wife, the contracting parties, do not amend or object to the terms and conditions of the contract, and sign the certificate anyway without reading the fine print, how should a state view this husband and wife? The state claims an interest in every child within its jurisdiction. The state will, if it deems it necessary, nullify their parental rights and appoint a guardian or trustee over the children. The subject of every birth certificate is the child, a valuable asset of the trust established by the birth certificate and Social Security number registration, enabling identifying, tracking, and accounting capabilities. Birth and marriage certificates are a form of securities called warehouse receipts. The items included on a warehouse receipt, as described, of the Uniform Commercial Code, the law which governs commercial paper and transactions, which parallel a marriage certificate are the date of issue of the receipt, the constructive number of the receipt, a description of the goods, or the packages containing them, the signature of the warehouseman, which may be made by his authorized agent. Black's Law, 7th edition, defines warehouse receipt as a warehouse receipt, which is considered a document of title, may be a negotiable instrument, and is often used for financing with inventory as security. Person means any individual, partnership, firm, joint stock company, corporation, association, trust, estate, or other legal entity. Human person, defined in Title 26 IRC, the IRS code. The term person, as used in the subchapter, includes an officer or employee of a corporation, or a member or employee of a partnership, who as such officer, employee, or member is under a duty to perform the act in respect of which the violation occurs. Include and including in terms of law mean to exclude any term not listed unless the terms are specifically addressed. Include and including means excludes and excluding everything else. It is a maxim of law that every person is a man, but not every man a person. As Black's Law Dictionary explains, the full capitalization of the letters of one's natural name results in a diminishing or complete loss of legal or citizenship status wherein one actually becomes a slave or an item of inventory. The method by which the state causes a natural person to volunteer himself into slavery is through forming legal joinder, implied or stated with the entity or legal fiction. That would be your all caps name. And the term for that is capitis diminutio maxima. And the definition of that is the maximum loss of status or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. Corporations are also of all grades and made for varied objects. All governments are corporations, created by usage and common consent, or grants and charters which create a body politic for prescribed purposes, but whether they are private, local, or general in their objects for the enjoyment of property or the exercise of power, they are all governed by the same rules of law as to the construction and the obligation of the instrument by which the incorporation is made. One universal rule of law protects persons and property. At common law, a corporation was an artificial person endowed with the legal capacity of perpetual succession, consisting either of a single individual, termed a corporation sole, or of a collection of several individuals, a corporation aggregate. Possession and ownership. Possession is not essential to ownership. Anyone may own property which he does not possess. Ownership is either several or joint. Security interest. The term security interest means a lien created by an agreement. Security agreement. The term security agreement means agreement that creates or provides for a security interest. Transfer. The term transfer means the creation of a lien, the retention of title as a security interest, the foreclosure of a debtor's equity of redemption, or each mode, direct or indirect, absolute or conditional, voluntary or involuntary, of disposing of or parting with property or an interest in property. A certificate is a paper establishing an ownership claim. Registration of births began in 1915 by the Bureau of Census, with all states adopting the practice by 1933. Internal Revenue Manual defines infant. An infant is the decedent of an estate or grantor, owner or trustor of a trust, guardianship, receivership, or custodianship that has yet to receive their SSN. Infant, a person under 21 years of age whose acts are in many cases either void or voidable. Tomlin's Law Dictionary. White House, March 3, 1997, Executive Order 13037, William J. Clinton, Commission to Study Capital Budgeting. By the authority vested in me as President by the Constitution and the laws of the United States of America, including the Federal Advisory Committee Act, as amended, it is hereby ordered as followed. There is established the Commission to Study Capital Budgeting. Commission. The appropriate definition of capital for federal budgeting, including use of capital for the federal government itself or the economy at large, ownership by the federal government or some other entity in physical and intangible or human capital. All crimes are commercial. Any of the following types of crime, federal or state, are commercial. Offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, and confidence game, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crimes. The words birth and date have specific legal meanings in law. Bouvier's Law Dictionary defines birth as the act of being wholly brought into this world. This definition restricts the legal meaning to the forensic act of our entire physical body, undamaged, unharmed, and all in one piece, being physically born from the womb of our mother into this world, or actual physical childbirth. Black's Law's Fifth, a modern revision, now defines birth as the act of being born or wholly brought into separate existence. Bouvier's does not include a legal definition of the word born, although Black's does. Bouvier's Student Edition, Law Merchant, the general body of commercial usages and matters relating to commerce. Black's Law Dictionary definition of born: act of being delivered, wholly or expelled from the mother's body. This is almost identical to that of Bouvier's birth, describing the birth of a man or woman. Here all in one piece or not? Would a baby rather be wholly brought or brought wholly into this world? If the choice were mine to consider, I would definitely prefer my baby's birth to be under the older legal definition of wholly brought every time, rather than today's alarming and nebulous definition of brought wholly into this world. Wholly brought, in the strict legal sense, means whatever is being born, the entity that comes out, is a baby all at once, all in one breathing, screaming, huggable, lovable piece. Brought wholly, in the strict legal sense, means that of all the generic entity, other than that of the flesh being born, being brought out completely and fully. So that means everything in comes out. It doesn't state the condition. The slight ambiguous alteration in Black's brought into separate existence, changing the meaning substantially to include more than one entity being born or formed, as in a non-living, artificial entity, like a corporation soul. Bouvier's defines date as the designation or indication in an instrument of writing of the time and place when and where it was made. Written instruments generally take effect from the day of their date, but the actual day of execution may be shown, though different from that which the instrument bears. Black's definition of date is the specification or mention in a written instrument of the time when it was made, executed. Executed meaning completed, carried into full effect, already done or performed, signed, take effect immediately, now in existence or in possession, conveying an immediate right or possession. Yeah, here's some funny things. So, courtrooms, what's allowed, what's not? Well, check this out. From court cases, a prosecutor may violate civil rights in initiating prosecution and presenting cases. A prosecutor may knowingly use false testimony and suppress evidence. A prosecutor may file charges without any investigation. A prosecutor may knowingly file charges against innocent persons for a crime that never occurred. A prosecutor may knowingly offer perjured testimony. Prosecutors are immune from lawsuit for conspiring with judges to determine outcome of judicial proceedings. Prosecutor can suppress evidence proving a defendant's innocence that he or she is knowingly in possession of and withholds. That's exculpatory evidence, by the way. The executive branch's nationwide collection agency, a single and separate business or unit called Title 40 Child Support, not only collects over $80 billion a year nationwide, at about $1.3 billion per clip on state franchise, but they also get to generate associated revenue for their other franchises, such as the Marshals, Department of Corrections, Parole, Probation, Secretary of State, to track down, hunt, harass, suspend, incarcerate, and as statute merchants create new or repeat offending felons out of all those who now qualify to come on down. You've won a $10,000 felony child support warrant. This includes an all-expense paid trip to several wonderful Level 4, Level 2, and Level 1, all-enclosed and all-inclusive state destination dad day camps for non-custodial fathers who do not have competent understanding how the child support entity actually operates and what steps that they can positively take that he can successfully make and implement to turn that super tanker right around in the other direction and go full speed ahead and get your rights as a father back. Stop paying the child support, become a dad 50-50 in parity with the mom. What other debt collectors do you know that can actually kidnap you or throw you into jail or prison? And why would they want to put these fathers on equal footing, precluding them from the child support obligation, and reduce their customer base and eliminating eliminating their vast majority of that income. Why would the state sacrifice that income stream just to supply the relief that fathers want and their children to see their dads? And if these men and children's interests take precedent over the state's prerogatives, you think that would ever happen? No. What if I showed you that things weren't really what they seem to be? That the family court process that we are all have grown so accustomed and used to isn't really what you think it might be. I sacrificed 5 years of my life in studying this. So what if I told you that there is a way that exists that unless you were specifically made aware of it and to spend a little bit of time looking into it yourself until you understand the underlying principles, you have never came to the knowledge of this, not on your own, not ever, not once, that, hey, I might be able to just do this on my own. I don't need a lawyer. Wow, this isn't as hard as I thought it was. What did I spend money on a lawyer for all this time? Oh, that's right, because he only knows procedure. He doesn't get into the underlying fundamental principles that statutorily construct our laws and what our natural rights are and what natural law is and what we as men are entitled to versus what we as persons are entitled to, or what our limited beneficial interests might be. I'll leave you on one thought, one last little quote from a court case. The one who is persuaded by honeyed words or moral suasion to testify or produce documents rather than to make a last-ditch stand simply loses the protection. Once he testifies as to part, he has waived his right and must, on cross-examination or otherwise, testifies as to the whole transaction. He must refuse to answer or produce and test the matter in contempt proceedings or by habeas corpus. The privilege against self-incrimination is neither accorded to the passive resistant nor the person who is ignorant of his rights, nor to one indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be claimed by attorney or solicitor. It is valid only when insisted upon by a belligerent claimant in person. If that gives you any idea of how things are, and you might have to ask 3 times. Remember that. It just might take to that 3rd time. Pick up this package. See what I would do if I was in your situation, or maybe what I did when I was in your situation. Thank you very much.